Hi everyone, my name is Patricia MacBride. Welcome to our session, A Comparative Perspective for documentary filmmakers in the United States and the United Kingdom. I'm going to introduce you to my panelists, Andrew Baker and Philip Wheeler, and I'll let them tell you a little bit about themselves, and then I guess we'll get started with the session. So Philip?
Yeah, hello everyone. My name is Philip Wheeler. I'm now a consultant to SmithDehn, which is the firm that we all represent. It's a firm that is based in the United States of America, but we also practice in the UK as well. My background, I started out as a journalist many, many years ago, but since changing to law in the mid-90s, I've worked for firms of solicitors that represent newspapers and publishers, and for the best part of 12 years before I joined SmithDehn at the beginning of this year, I worked at the BBC in the programme Legal Advice Department, and in that capacity I was providing legal advice to film producers, news reporters, editors, programme makers across the range of the corporation's output, TV, radio, online, everything from comedy to news. And I've done many, many documentaries in my time. I do current affairs documentaries. Panorama, the equivalent of Panorama in Northern Ireland, is a program called Spotlight, which is a very well-respected documentary strand. And I've done many observational documentary programs such as Traffic Cops, Motorway Cops, all of that sort of thing. So I have quite a considerable track record in advising film producers on the documentary side of things. So over to Andrew.
Thank you. So I'm Andrew Baker. I'm Head of Business Affairs at SmithDehn. My background is I started off life in-house at Granada Television up in Manchester. I ended up being Head of Business Affairs at Granada. I spent some time in Los Angeles working for Granada Entertainment. I then came back and worked for ITV Network, doing all the commissioning and acting for the broadcasters. And after that, I set my own consultancy firm up, and for 10 years, I've advised over 500 UK production companies, everyone from Darlow, Smithson, Pioneer, Raw, October Films, plus lots of independent one-man band production companies as well. So I'm now working with SmithDehn, and I'm very much more about the contractual and commercial side of negotiations and business affairs, as opposed to Phillip's, which is very much more about compliance and litigation.
And my name is Patricia MacBride, and I've been an admitted attorney in the United States for about 20 years. I work with SmithDehn running their dairy office, Director of Operations of the dairy office, and I do a lot of content legal advice in the United States. Some recent films I've worked on, We Are the Giant. I did some legal compliance work for that film for its release in the US. Chuck Norris versus Communism, another film that you might know of, another documentary. I've done tons of documentary content legal advice for films that are being released in the United States. I also do business advisory services in the US and transactional work in the US, as well as litigation. So that's our panel. And we're going to try our best to cover all the topics, but it's a very extensive area of the law. We've focused it on three main areas: fair dealing versus fair use, defamation, and privacy issues, things that regularly come up when you're making a documentary film that you need to be aware of, issues that you need to be concerned about, and ways about which you can mitigate your risks when you're creating your product and trying to market it and sell it. But these are the three main areas that we're going to try to focus on, and then give you kind of a business side, business focus as well, not just a legal focus, because you are creating a product that you're trying to get out into the industry and have people see. So it's important not just to look at it from a legal perspective, but also from a business perspective. So we're going to start with the first topic, fair dealing and fair use. We have a limited amount of time, so we're going to give you an overall or general view of the area. It's going to be too difficult to go into specifics, but we'll field questions during the course of our presentation. So if you have any questions of us, just raise your hand. We'll do our best to answer them during the course of the presentation. The only other thing I would say to you is maybe we could get a feel for who's in the room, so we have an idea of how to maybe present in the best fashion possible. So how many filmmakers are there, or documentary filmmakers are there in the room right now? And how many of you are independent documentary? Okay, very good. All right, great. So I'm going to hand it over to Philip because the first topic area is going to be fair dealing versus fair use. Fair dealing is a UK concept and fair use is a US concept. And Philip is experienced in the fair dealing concept, so I'm going to hand it over to Philip.
Well, hello again. Just a little remark. It seems to me that this is a bit of a competition between the US and the UK side of things. So I think at the end of this, we're going to need a show of hands to see which is the easier jurisdiction in which to operate. So we're talking about fair dealing. It's a UK concept, but let me just put it into a sort of global perspective for you. This is all within the field of copyright. So copyright is the area of law which allows people who create content to protect it and to make money out of it, essentially. So if you own the copyright in something, in most cases, if somebody wants to copy that, then they need your permission to do it. And in most circumstances, what they would do is, if they're seeking to use that in a commercial way, which of course documentary makers would be doing when they're making films, they would require you to pay a fee to do that. So the most obvious way of not infringing the copyright owner's copyright is to pay for the use of it. Now, there may be occasions when you don't have to do that, and in the UK, this is the body of law which is called fair dealing. So fair dealing effectively is a way of using somebody else's copyright content without having to pay for it. So it's a wonderful little thing if you can get within it. So let's have a think about what the types of fair dealing that the UK law now provides. Well, there have been some very helpful changes within the last few months, but the two established ones you'll see on your screen there, fair dealing for the purposes of criticism or review of that or another work. So what you can do is you can take, for example, if you're doing a film about sort of works of art, you can use that work of art and you can show an image of it, and then you can talk about it in a way which is either criticizing it or reviewing it. And that is a way that you can legitimately use somebody else's copyrighted content and not have to pay for it. So criticism or review is the first main heading. There are some specific things that you have to do. You have to give an acknowledgement, a sufficient acknowledgement of the title and the author of the work. And it's got to have been something which has previously been made available to the public. But in theory, that's a very, very useful way of using somebody else's copyright in any type of work. So that's the criticism or review heading. The second one is, again, it's particularly useful for those who are doing the sort of current affairs style of documentary. If you're doing something about a current event or current events in general, then you can fair deal most copyright works for that purpose. The key thing that you can't fair deal under the reporting of news and current events heading is photographs. Ever since the Copyright Designs and Patents Act of 1988 came out, photographs have been treated in a sort of sanctified way, effectively. I think it's because at that time it was specifically intended to prevent one newspaper ripping off another newspaper's photography. So there was that sort of carve out. So photographs are something that you cannot fair deal when you're reporting news and current events. But effectively everything else you can. And again, all you have to do is give a sufficient acknowledgement of the title and author of that copyright work. So in theory, for all but photographs, it's an absolutely wonderful way of enabling you to include bits of work created by other people within your film, but not having to pay for it. So, I mean, if you're doing, let's say, the most obvious way of doing it is using clips from somebody else's film or content in your film. And as long as you do it legitimately for the purpose of reporting current events, that's fine. And you've got to give that acknowledgement that I've mentioned of the title and the author. And you're away and home and dry. So that's a very useful second one. Remember that photographs are something that's specifically excluded from that provision. So on we come to the two newbies into this particular area. The first one is up on screen. The second one is not. And I'll tell you why I didn't put the second one up on screen in a second. Parody, caricature, or pastiche. I mean, there are definitions, pretty clear established definitions of what those are, so I won't have to explain it to you. But again, it's possible for content makers, it's not obviously relevant particularly for documentary filmmakers, but it is possible for content makers to do a sort of satirical parody of somebody else's work, or to make a caricature of that. And again, provided you meet the conditions which are set out in the Act, which are very similar to the ones I've already set out, then you can use that copyright material without having to pay for it. The one I've not mentioned it because the wording of the Act is rather misleading, or at least the word that has been chosen by the drafters of the legislation is one that has, in most normal context, a quite specific meaning, and that is quotation. So you're now able to fair deal for the purposes of quotation, okay? And that is something you can do for any type of work, including photographs. Now, the interesting thing about that is when we all have a sort of fairly clear working idea of what quotation means. Well, you might have a book, and there's a little passage that you select, and it's for the purpose of quoting as an example of the thesis of the work in question. But if you think about that type of quotation, it's quite a misleading concept because copyright goes across the genres. You've got literary, you've got dramatic, you've got artistic works. So how do you quote from that type of thing? Well, if you're using a clip of somebody else's film, that is, in a sense, quotation, is it not? What about other types of work, visual works, works of art? All of those things, at least in theory under the Act, you're now able to quote from, in other words, use a snippet of. So the point I'm getting to is, well, if all bits of work, of content, all types of work that are susceptible to copyright are capable of now being quoted from in a fair way to get you within the fair dealing provisions, what about photographs? Can you do that? Because you couldn't do it for reporting current events. You could criticize and review photographs. That's one way, but you couldn't do it for reporting current events. What if you try and sort of if you try and quote a photograph? Interesting concept. The law has not yet been set out by any judgment on this, so we're still waiting to see whether it is permissible now to quote a photograph, in other words, show at least part of it to make the point that you want to make. So there have been some significant advancements in the area of fair dealing, which have really liberalised the sort of field of play as far as the UK is concerned. So fair dealing, a very, very helpful tool for documentary makers, any type of filmmakers under UK law. Hi there. At this point, I have to pass you on to Patricia because she's going to tell you what the perspective is from the US end. Well, if you're, this is something about copyright law. I mean, not all the laws are harmonious across the globe. So, in any territory, you have to consider your copyright exposure under the jurisdiction that you're selling to. So all I can advise you on is what the UK law is. So if you're selling to different jurisdictions, then you will have to think at least about what your exposure is under the domestic jurisdiction.
In practical terms, excuse me. In practical terms, what tends to happen is that if your film is being distributed internationally, your distributor will require you to have cleared all of your material. So one of the points we'll talk about a bit later is actually the commercial side of this, which is that fair dealing is a really powerful tool that you can use, but it's also very limited. So you can fair deal in the UK, you can fair use in the USA, and that works really well for those territories, but it doesn't necessarily work for the rest of the world. So you're then into questions of, do you have different versions for different territories? But the standard kind of practical answer is, if you have a Storyville commission, you might be able to fair deal some content. If you then have an international version, you'll have to change it.
So there are huge differences between fair dealing and fair use in the United States. As I said before, it's a U.S. concept. It's the same idea, though. It's the idea that if you're using a copyrighted material, you may not have to license that material if it falls within this fair use doctrine. There's an important document that anybody who's intending making a documentary in the United States should, you should be reading it. I've put the link up onto the website if you have time to copy it down. It's a documentary filmmaker's statement of best practices in fair use. It is really probably one of the most important documents you're going to read if you're making a documentary that you intend to release in the U.S. Most insurance companies now are more inclined to provide insurance cheaply, more affordably to filmmakers that are following these guidelines. So if you're familiar with them, you stick by them, you're more likely to get insurance for your film, you're more likely to get it at an affordable price, because the insurance companies recognize that if you're following these practices, you're minimizing the risk of litigation or the risk of problems coming up from your content. So I highly recommend becoming familiar with that document. Fair use is an interesting concept in the United States. Basically, it's a lot different from the UK concept because it's a more general one. As Philip was describing to you, there are specific exceptions that provide you the ability to use material in the UK, whereas in the US, it's a test, and it's much more flexible. You don't have this restriction that it has to fall within a specific category to be able to use the material. But you have to remember that it's a defense, and as Andrew was saying, basically you're not immune from claims. It just is that if somebody is annoyed that you've used their material and they bring a claim against you, it's a defense that you can use against that claim. In the United States, it's a very good defense, and often we get clients who come to us who have gotten a letter from someone that's annoyed that they've used their material, and we write a quick letter back just basically telling them this is why it's fair use, and if you bring a claim, we'll be seeking costs from you because you're not going to prevail. And usually, if someone's properly followed the guidelines and it is truly fair use, they prevail. So, but again, as Andrew was saying, it's a very good point that it's a business issue too. It's not just about, fair use. It's also about the idea that you want the path of least resistance to getting your product out there. So the fail-safe, in my mind, is always do your best to get a license if you can, and if you can't, then fair use it. It's very different in the UK. I know that I think there's difficulty with, in the US, if you approach a copyright holder and ask them for a license and they deny you that license, that doesn't work against you in court. So if down the road somebody brings a claim against you in court, the fact that you've actually approached them for a license and they've refused you the license will not work against you in the United States. But I think that may be different in the UK, and that may actually work against you in the United Kingdom.
It doesn't necessarily, but the key thing is fair use. So the use has got to be fair. What that means depends on the circumstances, but at least one factor might be the negotiations that you had and how those progressed. I'm not saying it's necessarily going to be a decisive factor, but it's at least a factor that's going to be in play. I didn't go into this when I was doing my little spiel, but one thing that is always key when you're talking about fair dealing is how much of a work you use. Clearly, copyright is designed to protect people's ability to exploit their own, the works that they've produced. So if you're doing this in a way that is going to affect somebody's ability to do that financially, then the less likely it is that that's going to be fair dealing at all.
And in the US, that wouldn't matter. The fact that, you're not getting the license and that you're going to fair use the material because you can't afford it, that wouldn't really play into an evaluation by the court. The issue is whether or not the material is fair use. So there's a 4-factor test. The first factor, one of the most important ones, is the purpose and character of the use. If you are taking an original piece of material and you're transforming the use of that material in your documentary, you are well on your way to fair using the material. Most documentaries and the material in them are going to meet that standard because they're going to be relevant. You're using them for the purposes of commentary or criticism or news reporting or historical reference points or parody or satire. So if your material that you're using is for that purpose in your documentary, you're well on your way to fair using the material. For example, if you take a movie clip and it's relevant to something that someone's saying or a point that someone's making in a documentary, or one of your commentators is making a point in a documentary and the clip is relevant to that point, you can use that clip. And later on, I'll give you some examples, but that's the first part of that test. Are you transforming it, or are you simply just copying the material? So a movie clip its original purpose is to entertain. You're using it in your documentary maybe to provide a historical reference point about a certain period of time, or to provide social commentary on an issue of importance, and that is going to be transformative. The second part would be, yes? Well, I'm happy to take a question now, yep. Right. Whether the material has a warning on it or not, it's whether or not you're transforming the use of the material. So if, for example, a film that I recently worked on, Listen to Me, Marlon, it was a documentary film, biopic of Marlon Brando's life, and from his own recordings, his own voice recordings, and clips in the film were used from A Streetcar Named Desire, On the Waterfront, some pivotal scenes from those movies, but they were highly relevant to the commentary, to Brando's commentary at the time. From many perspectives, not just historical, but just him providing basically a biopic about his life.
And you could acquire those clips easily?
Those clips, whether you can acquire the clips easily or not is not relevant to the question of fair use. It's whether or not you're transforming the use of those clips. The clips were originally used for the purpose of entertainment. The filmmaker made the film to entertain people, and people could go out and watch the film. Now you're using the clips in your documentary in order to tell the story of Marlon Brando's life and what was going on in his life at the time that he was making those films. And those films are highly relevant to that story.
Okay. My other query was for Philip, is it?
It is Philip.
I'm Philip as well. Pastiche is so broad. I've tried to teach that subject, and pastiche doesn't.
Sorry, I missed the first bit.
Pastiche.
Yes.
Doesn't have to be comedic. I mean, pastiche could be, say, a homage, for instance. So it's so broad. I'm just wondering if there are any boundaries at all.
Well, it's another one where the law is very fresh. It came in at the end of 2014. So. Where were we now? We're about 6 months into 2015. So these things are not yet bedded down in terms of how they'll be interpreted by the courts. Right. So as far as I'm aware, there hasn't yet been a case that's gone through to trial and has been considered by a judge where these definitions have been considered. So on the face of it, I agree with you. It's very broad. I mean, pastiche is basically, it's taking lots of bits from lots of different places. Yeah. And, who knows where these developments are going to go, but on the face of it, the climate is certainly being liberalised.
Thank you.
The second part of the test is the nature of the copyrighted work. There's going to be a difference in how the work is treated, if it's published or non-published work that you're, using, or if it's a creative or factual work. But the creative nature of the work is not dispositive on that question. And normally, if you meet the first part of the test, you'll probably be okay on the second part of the test. The third part is the amount and substantiality of the use of the original copyrighted material, and Philip was discussing that previously. If you're taking 6 seconds of a 108-minute film you know, to make a point in your documentary, that's not really substantial in the U.S. court's eyes, so you're probably going to be okay with that type of material. But again, this test is all, you know, a fluid test, it's a general test, and really it's evaluated on a case-by-case basis. And I would recommend to anybody making a film that it's worth taking the time to actually get an opinion letter from counsel, or an opinion letter from someone basically, you know, securing insurance to protect yourself. But Andrew's going to discuss that later on. The effect of the use of the work is also an important issue. If your use of the material basically ruins the market for the original copyrighted work, you're going to have a problem. But most of the time in documentaries, that's not the case. So as a documentary filmmaker, as long as you're not ruining the market for the original work, and a lot of times actually documentary films increase interest in the original work. Like if someone references a book in a documentary or references a film in the documentary, a lot of people, I've done it myself where I've watched documentaries and things have been referenced and then I went out and watched the movie and I hadn't watched it before. So, but you have to be able to establish that you've not ruined the market for the original work. So that's the US 4-factor test. It can't be seen as in a vacuum, but it's not as restrictive, I think, as the UK test because you don't have these specific exceptions. It's a more general rule. And I kind of wanted to give you some examples of film clips and music clips that were not licensed. One you may know about, Expelled, No Intelligence Allowed. It was a documentary where they used a music clip from a Lennon song, Imagine. And they also used the words from the song in the background. The documentary filmmaker was using that music clip as a point. They were trying to show, I think, from the clip, the naivete of the writer of the song, John Lennon. And it was in the backdrop of like war footage. And they got sued by Yoko Ono and EMI Records. And I think it was Stanford University as a pro bono project where they help documentary filmmakers and defend them when litigation's brought against them. And they defended the filmmaker and they prevailed because it was found to be transformative, it was found to be fair use, and it was a music clip. But I would say you got to be really careful with music. I think, in my personal opinion, it's dealt with very differently from film clips, and you can't just go around using music from artists without getting the material licensed, especially if you synchronize the music in your documentary. You're going to run into trouble if you don't have a license. But generally, if you're making a documentary and you're interviewing someone and their television's playing in the background or their radio's playing in the background, you know, that's fair use as long as you haven't instructed them to turn their television on. And believe me, you'll get caught. So I wouldn't play that game of like doing it and then just pretending like it didn't happen. Just don't do it. If somebody happens to be playing the radio or watching the television, as long as you're not telling them to turn the TV on or telling them to play the music and you're just catching them in their natural environment, it's considered incidental and you're safe.
Can I just interject at that point? We have something very similar here. So incidental use, again, is a sort of an exception to copyright infringement. So it's exactly the sort of circumstances that Patricia has just outlined. The second thing I'd like to say is I absolutely echo what she says about music being treated very differently from other types of copyright work. In theory, it is possible to fair deal music. There's nothing that says that you can't, but it's pretty clear that you know, if you're using somebody else's copyright music, then they're going to come after you. Okay, so it's something that you have to treat very, very carefully. We were talking just before the session started about, you know, a couple of recent occasions where people have got credits for writing songs that they didn't write. So, you know, the most recent one is Tom Petty getting a co-credit for the Sam Smith song on the basis that Sam Smith must have, you know, inadvertently ripped off one of his songs, a Tom Petty song. So music is very, very, what's the word, vigorously policed.
Yes.
Can I just ask, is the incidental inclusion clause, does that also apply to images, logos? Because obviously US shows you see everything is heavily blurred.
It depends. You know, it's in the U.S. the whole idea is it necessary? I recently watched a film where they used the same clip 3 different times, and it was this big, beautiful piece of artwork. And it's not dispositive, the issue of necessity, but it's certainly going to weigh in the court's mind. And things that, like the piece of artwork that was in the background wasn't necessarily relevant to the point that the documentary filmmaker was making in the documentary. So I think you need to be careful, like, you know, in that particular situation, we advised them that they should take out 2 of the clips because it wasn't necessary to have 3 separate clips of people standing in a location where there was a big, beautiful piece of artwork in the background. But you need to be careful because certainly if you go and if you're picking a location to interview someone and it happens to be that they're sitting in front of a piece of artwork, when you're conducting that location, you've placed them in that location. You're going to have a hard time making the argument that that's fair use because you've picked the location.
And if it's more kind of a glimpse, you know, walking through shot, there's a huge Starbucks logo behind them, but you're naturally following that person. In that case, would that be seen as incidental? That's
nominative fair use, and you're going to be safe in that particular situation.
The only kind of slight caveat to that is just about the prominence. So it's all well and good if you're walking down a street and it's a typical high street and there's shop logos all over the place, that's fine. If you're doing a static shot and the logo is kind of, you know, behind their head and all you can see is this person and this massive logo just behind them and you've fixed the camera for a 3-minute interview, that's probably going to be undue prominence. Yeah. So you just need to be careful. It's very, very much about context. The other thing I would add is that US broadcasters in particular are very, very nervous about trademarks. So even though technically you don't have to clear trademarks because they're incidental, they're not undue prominence, you know, that they're just kind of in the background, the majority of UK broadcasters will actually say if there's a trademark in shot, it has to be cleared or blurred. So you do have to be very careful about that.
So a film that I recently worked on, Chuck Norris versus Communism, there was extensive use of film clips in that documentary. The documentary filmmaker was trying to portray the communist state in Romania and the use of illegal underground selling of VHS tapes to people living in Romania of American films that had been censored by the Romanian government, trying to show that that content kind of led to or contributed to the downfall of the communist state in Romania. And there was extensive use through, well, I wouldn't say extensive, but there was use of film clips from those movies in order to make the point. But it was highly relevant. They were recreating scenes of people living in Romania and reenactments of people watching these movies as a group, and then people giving commentary about how watching these films affect their perception of the way they were living in Romania, and that it didn't make sense, and that people were living a better life somewhere else. And they started to realize maybe they were being sold a bag of goods from watching these films. So the use of the clips were relevant to the point the documentary filmmaker was trying to make about this woman, Irina Nister, and about her involvement working in the censor board, but yet being a part of this organization that was underground selling these tapes, and how this led ultimately to the demise of the totalitarian regime in Romania. So a lot of that material was fair use because it was relevant to the point the documentary filmmaker was trying to make. And I talked to you before about Listen to Me, Marlon. So again, a lot of the clips that were used from that film were fair used. Although most of the material was licensed, you could have said that the material was fair use. You could have fair used the material as well. But like I said, I think as a business decision, it's probably always better if you can get a license to get a license. And that's what I would always tell clients is ask and see if you can get the license first. So I think we're going to have to move on to the next subject because we're kind of behind on the clock. But the next major subject would be defamation. And there's definitely a huge difference between the United States and the United Kingdom. But I'm going to let Philip start by first discussing with you defamation in the United Kingdom.
Okay, well, defamation, certainly in terms of the legal issues that affect the content of what people put on television screens or in films, defamation is probably the daddy still. It's a very big area of law, and the risks are quite high. So it's a civil cause of action, and actions for damages can cost hundreds of thousands of pounds in damages, but then the costs on top of that will be several times more. So you're possibly looking at £1 or £2 million per claim in a defamation case that goes to trial. Fortunately, there aren't that many of those these days. A few years ago, that was not the case, and defamation was a much scarier beast than it is now. One of the reasons defamation is no longer quite such a scary beast as it used to be is the Defamation Act of 2013, which came into force about 15 months ago. What that did was to set a higher bar that a claimant would have to surmount before they could bring a successful action in defamation. So there's a definition up on screen in front of you, which provides that a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. Now, there's been one case so far which has set out what the parameters of the definition serious harm might be. But it's pretty clear from that one case, and I can give you some background about that case if you'd like. It's pretty clear that what the sort of things that used to be little niggly, troublesome allegations about somebody are no longer going to be as much of a problem as they used to be, unless a claimant can show that they've actually suffered some sort of tangible harm to their reputation. So they'd have to produce money, or they'd have to show some sort of loss of money or real loss to their reputation. They can't just go to the court and say, something nasty's been said about me, I don't like it, and just assume that that would be sufficient to go over the line. Now there has to be something which is really tangible. So I go back to the definition, has caused or is likely to cause serious harm to the reputation of the claimant. When you're talking about what's called bodies that trade for profit, in other words, companies, any type of business effectively that is in the business of making money, the concept of serious harm has got an even more refined meaning, and it equates to serious financial loss. So when you're talking about, let's say, a massive organization, a sort of a multinational, or if you're talking about the likes of a Tesco with a huge sort of balance sheet of billions of pounds, the level that harm would be, or financial loss would have to be serious financial loss, is going to be really significant. We're not talking about trivial thousands, we're talking about something that's much more significant than that. So there's been a liberalisation in the UK of the way the defamation law works. We can talk about defences in a minute, but for a claimant to get a valid claim in play these days, they have to surmount this serious harm test, and that's a really good thing.
It's very different in the United States. The definition is very different. It has to be a false statement of fact of and concerning the plaintiff, and it actually has to injure the plaintiff. One of the key differences in the United States, free speech is a right under the Constitution. It's a very, the U.S. takes your constitutional rights very seriously. Legislators want to get reelected, so they're not going to write legislation that undermines, or most of the time not going to write legislation that undermines any constitutional rights. Judges are going to enforce constitutional rights because it's an important concept in the U.S., and free speech is right up there. It's the First Amendment. And so it's not likely that your free speech is going to be limited in the United States, except in certain circumstances, one of them being if you're defaming someone, if there's an act of defamation. But the law in the United States has taken into consideration the importance of that right and the importance of not chilling speech. So it's very, very difficult to bring a defamation claim for a plaintiff. It's very difficult in the United States for a plaintiff to prevail if they bring a defamation claim. I think that's the reason why you see a lot of people forum shopping and a lot of stars bringing claims in the United Kingdom over the United States, because there's more likelihood of prevailing on a defamation claim if the defamation has been published in the United Kingdom. Then, you know, that person's going to have a greater likelihood of prevailing on a claim in the United Kingdom than they would in the United States. One of the major differences between the UK and the United States is the burden of proof. In the United States, a plaintiff has to prove that the statement is not true. That's a hurdle. That you have to prove that it's a false statement. So if somebody says you're a tramp, and you have to prove you're not a tramp, it's a very difficult burden to overcome. And so there's not a lot of defamation litigation, and when there is, unless you're getting past the point of summary judgment, you're probably going to go away. Summary judgment is a motion that if your client was sued for defamation, the first thing you would do is move for summary judgment and say they haven't met their burden, they haven't established that the statement's false. And if the plaintiff can't do that, then the claim is gone. It's quite different in England, and I don't want to speak to how the English legislation works. Phillip is more experienced in that area than I am, but that's one of the main differences, and it's a huge hurdle. It makes it much more difficult to bring that type of litigation in the US.
In the UK, it's the polar opposite of what you've just heard. So just to give you the sort of the key elements that a claimant would have to establish for their defamation claim. Pre the Defamation Act of 2013 and the serious harm definition that I mentioned just now, there were three things, and only three things, that needed to be shown by a claimant to get a valid defamation claim in court and up and running. The first is that you're identifiable in what was said or what was shown. And the second was that was in conjunction with a statement which was defamatory. And the third was that the thing was published to at least one other person. Okay? So there has to be the publication of some matter, some material, in which you're identifiable in the context of an allegation that's defamatory. There were various definitions of what was meant by defamatory, but generally speaking, all you had to show pre-2014 was that it was something that was, you know, marginally on the wrong side of nasty, as it were. You didn't have to show that it was untrue. You didn't have to show that you suffered any loss at all, and you didn't have to show that there was any intention on the part of the publisher to injure you at all. Those general concepts still apply, subject only to this serious harm test. So it's still not the case that the claimant has to prove that what was said about them was false. What the case is that it is presumed to be false unless the defendant can show that it was in fact true, if it's an allegation of fact and they want to defend it as being a true allegation of fact. No burden on the claimant in that respect at all.
Some of the defenses are quite different as well between the United States and the United Kingdom. In the United States, one of the defenses obviously is the truth. Another one is opinion. And it's not a qualified opinion. It's not an honest opinion. It just has to be an opinion. So in other words, if the person in your film is making a statement and it's not a statement of fact, it's just an opinion, and it's clear to a reasonable person that it's an opinion, then you're not going to fall afoul of the defamation law. So hyperbole, like nonsense opinions saying ridiculous things, like I think often of like the differences between Gogglebox and People's Couch, which would be the equivalent of Gogglebox. Sometimes some of the people watching the shows and People's Couch say ridiculous things that you know they don't know. They clearly don't know the people that they're watching on the show, but they make ridiculous statements that maybe could be considered defamatory, or somebody might have an argument that it's defamatory, although I don't think they would win on that argument. But those statements are clearly hyperbole. They're not statements of fact. They're ridiculous. No one would believe it to be true. It's obviously, opinion. So that's a defense. Another defense would be fair report and comment. So if you have a documentary you're doing and you it involves a court case and a judge has made a statement in court, you have the right to repeat the statement that the judge made. You can't adopt the statement as your own. In other words, you can't go out and say, Joe murdered Julie, but if the judge said Joe murdered Julie, you can say the judge reported or the judge stated that Joe murdered Julie, and that's fair reporting. But there's always the difficulty, too. You have to be careful because since that statement was made, there's evidence that Joe didn't murder Julie, and you repeat that statement of the judge, you could run into trouble if down the line it turns out that that statement of the judge is incorrect and you didn't do your investigation and check to make sure that the statement was still a good statement. And then there's fair comment, which is another defense. And if everybody's talking about it and everybody's got an opinion on it and all the news pundits are commenting on it, you can comment on it. And that's fair comment. So those are some of the major defenses to defamation. And when you're a documentary filmmaker, and you're making these films, it's important to understand that implying something without actually saying it is probably not going to get you into trouble. Like, I would think of a documentary film like Searching for Sugarman. They don't actually ever. The documentary is about a music maker who never knew he made any money. And apparently his album was being sold throughout South Africa, and he was famous in South Africa. He was an American guy, and he never knew this, and he apparently never received any proceeds from the sales of his albums, and no one knows where that money went. And throughout the documentary, various people from record companies are interviewed. No one actually says that anybody took anything or that anything wrong was done, but it's implicit from the conversations that something's happened. Who's responsible? It's not clear. But that documentary is not defamatory because you're not saying anybody took anything. It's like you're not coming out and accusing anyone or making statements that anybody has taken anything. It's not clear what happened to the money. And when you watch the documentary, that's evident by the end of the documentary, that it's not clear what happened to the money, who was responsible for the money and where it went, and why this guy is living almost a poor life in another country, yet he's this famous music maker in South Africa. So those types of statements are treated very differently, I think, in the United States than they are in the UK. But I'm going to let Phillip talk about the defenses in the United Kingdom.
Oh, yes, indeed. They will be treated very differently in the United Kingdom. The law of defamation is all about meaning. It's not about what the words are. It's about what they mean. So you have to stand back and look at all the context and come up with, or at least a judge would be tasked with the job of establishing what the meaning of the allegation complained of would be. So while Patricia can very happily say that in the US, no one said that anyone took anything at all, if the meaning is that, oh yes, indeed, they did take something, then that is the meaning that you'd have to defend. And you'd have to, if you're defending it as being a true statement, then how would you do that? Well, you have to produce evidence which is sufficient to meet that allegation. You have to show that there was indeed wrongful appropriation of somebody's legitimate receipts from their work. So just to give you an example of this, I mean, I'm sure you're all familiar with the name Sally Bercow, the wife of the Speaker. She was sued in defamation by Lord McAlpine. This is all in the aftermath of the infamous BBC Panorama and Newsnight programmes. The Panorama programme about Jimmy Savile, which didn't go out, and then the Newsnight programme about Lord McAlpine that did. In the Newsnight programme, which was about Lord McAlpine, but didn't actually name him and used every term of reference under the sun with a view to not identifying him specifically. That caused a huge storm because it was all about the allegations of historical abuse of children, paedophile abuse of children, involving people in the higher echelons of society. And everybody wanted to know who that person was. Various names came out as to who it might be, one of which was Lord McAlpine. And the way that Lord McAlpine's name became fixed with those allegations was that somebody at Newsnight told a former colleague who was a reporter on a rival station, and that person basically was a friend of Lord McAlpine and went to Lord McAlpine and said, by the way, that Newsnight broadcast was about you, and wrote a piece for one of the newspapers which basically said how outraged Lord McAlpine was about the insinuations that had been made against him. And in that sort of maelstrom of activity, Sally Bercow tweeted, because she's got a habit for tweeting, why is Lord McAlpine trending? Innocent face. And he sued her. And so the whole thing was about what that tweet meant. She said, well, I just was looking at what was going on at the time, and I was asking this question, why is Lord McAlpine trending on Twitter? Because I genuinely wanted to know the answer. Not surprisingly, the judge had none of that. And basically, the meaning that he said that that tweet bore, in all the circumstances, was Lord McAlpine is a paedophile. Simple as that. And she couldn't prove that. In fact, she didn't even try to prove that. And so she lost the case. So if you want one very, very recent example of how you can fall foul of the UK law of defamation by using weasel words, there you have it.
I don't think you would have gotten the same result in the United States. I think if that had happened in the US, it probably would have been treated, it's possible you could have made a really good argument that it was fair comment, that it was opinion. There was nothing from that statement necessarily in the US that it could be gleaned as being a statement of fact, because how would she know that he was a pedophile? You'd have to have some belief that she had some knowledge, a reasonable belief that it was true. So I think in the US, that statement would probably be defamation proof. Like, in other words, not defamation proof, that's a bad word to use, but it would be a lot less likely that you would prevail on a claim for defamation if you use that comment in the US, especially if other people were talking about it and the press was talking about the subject matter at the time, and she was just making a fair comment about something that he was doing. I don't know if you would necessarily get, that you would prevail on a defamation claim in the US on that, because it wouldn't be seen as a statement of fact. So that would be a perfect example of, I think, how things would be very different in the US versus the UK. I don't know if you want to comment on any of the other defenses, Philip, just because we're time-wise.
We're sort of short of time. Most of them speak for themselves. I mean, truth is, it does what it says on the tin. It only applies to allegations of fact. So facts are susceptible of proof or disproof, okay? And if your evidence is good enough to meet the allegation that you're making, then the defense of truth will come to your aid. Honest opinion is what used to be called fair comment. It's another change in the law as a result of the Defamation Act of 2013. Fair comment, which is its predecessor, was the most fraught defense you could possibly imagine, even though it was a form of words that almost everybody would kind of use. Well, that's fair comment, you'd say. It was so restrictive in the way that it applied that it almost became redundant as a workable defence. So the new successor, this honest opinion defence, which has just been brought into force, is designed to sort of make things a little bit more real world. And it should be okay, but it only applies when when the statement in question is a statement of opinion as distinct from a statement of fact. And if that's the case, and provided there's at least the basis hinted at within the same publication, and it's the sort of thing that an honest person could hold as an opinion, then you're home and dry. I think that's probably all I should say in the interest of time.
And just, everything we're talking to you about is in a very general way. I always say it's important that you have someone vetting your material, from a legal standpoint, just to make sure you're okay, because sometimes what applies in one situation might not apply in another. And the overall context of what you're saying could become defamatory if you're doing it in a particular way in a film. So I think it's important that you're always seeking out some sort of assistance in that regard, if you can, but Andrew's going to talk about that in a little bit. But just to move on, this is a concept that it's not really, it doesn't go on in the U.S. I mean, I'm sure all of you are very aware of the O.J. Simpson trial. That got tons of publicity. The U.S. doesn't put restrictions necessarily on reporting criminal activity. It's, again, a First Amendment free speech issue. What happens is if it prejudices the defendant, they just move the trial to another location. The defendant moves to the court saying, I've been prejudiced by all this publicity, I need a trial in another location. I think that's what O.J. Simpson did in his case. He moved his trial from Brentwood to downtown LA, and he argued that he couldn't get a fair trial in Brentwood because of all the publicity. And so it's quite different, and I'm not as familiar with the UK position on it, but I know from speaking with Phillip that it is different, so I'm going to let Phillip speak about the UK position on that.
Yeah, so if your program is something where you're reporting crimes or anything to do with cases that have gone to courts, then you need to think about a couple of things. The first one is something called contempt of court, and the second one is other types of reporting restrictions that might apply in specific circumstances. So contempt of court applies to all types of cases, criminal, civil, coroner's courts, all that sort of thing. Any court of this country, and it's there's the Contempt of Court Act 1981, which is the body of law which deals with this. And basically, if you've got a case which is called an active case, so if it's a criminal case, if it's one where an arrest has been made or another similar type of step has been taken, then if during that active period, which goes from the point of arrest typically until when the judge passes a sentence, assuming that person is prosecuted and convicted, if you publish during that time material which would tend to create a substantial risk that the course of justice in the proceedings in question will be seriously impeded or prejudiced, then you'll be in contempt of court regardless of whether you intended to or not. And contempt of court is like a maxed up criminal offence, okay? It's a very, very serious thing. So not only could you or let's say the broadcaster of your work be jailed, at least in theory, for up to 6 months, there's also the potential for an unlimited fine. And we're talking tens of thousands of pounds for a successful contempt of court prosecution. And it's a very, very serious sanction. So when you are dealing with ongoing court cases, think about contempt of court. First of all, are there active proceedings? And if so, is what you're publishing going to create a substantial risk that the course of justice in those proceedings will be seriously impeded or prejudiced? That's contempt of court. If you're dealing with cases that have been through the courts or are currently going through the courts, then there may be specific reporting restrictions that might apply. Typically, the sorts of thing I'm thinking about are if you've got people who are involved in that case who are under the age of 18, so a defendant or a witness under the age of 18. If so, it's not necessarily going to be the case, but it's very likely going to be the case that either an order of the court will have been made protecting that person's identity, or some sort of automatic restriction will also apply, protecting that person's identity. So under 18s, generally speaking, benefit from anonymity. The other big category is when you're dealing with cases involving a sexual offence. If there's an allegation of a sexual offence, whether that complaint is made by the person who alleged that they suffered that sexual offence, or by somebody else on their behalf, then from that moment onwards, that person has anonymity for their lifetime in respect of that allegation until such time as they choose to waive it in writing. Okay? So sexual offences, under 18s, those things should set alarm bells going in your mind. Okay.
It's, as I said before, it's very different in the United States involving sexual offenses. They don't particularly have to waive it in writing. If people are giving interviews to the press, if a rape victim is giving an interview to the press, she's made her name public, it's probably pretty much okay for you to use that material from that point forward. As far as defendants, there's no reporting restrictions on naming people who are being convicted of sexual offenses or prosecuted for sexual offenses. They're part of the public record. Anybody can get them, so the courts won't restrict you from reporting on that material in the United States. So it's quite different.
We don't have restrictions on the perpetrators. It's just on the victims, identifying the victims.
So those are some major differences in that area. Then there's also some similarities, obviously. One of the key things in the U.S. is that you have to have fault to be done for defamation. So if it's innocent, you're not going to get in trouble. But if it's a different standard depending on whether or not a person's a private individual or they're considered a public official or public figure. There's various types of public figures, but the standard for a public official or public figure is actual malice. And that doesn't mean that you're being mean. It means that you knew it was false, what you were saying, or you knew that the position you were portraying in your documentary was false, or you had reckless disregard for the truth. Someone was telling you that the information was false and you were doing nothing to check it out or not getting any sources to back up what you were reporting in your documentary. That's actual malice, and that applies to public officials and public figures. And again, that's a First Amendment issue. The courts in the United States don't want to chill free speech. Public officials and public figures are important people that influence society, and the courts want people to be able to comment and criticize them without being afraid of being sued for defamation. So they create the standard of fault in their regard as a higher standard to meet. It's very difficult to achieve that burden, to get over that hurdle and establish actual malice. If it's a private individual, then the standard is negligent, that you didn't have due care when you were reporting and you defamed them. So it's a lot easier if it's a private individual to sue for defamation. But it's interesting, public officials and public figures can be, sometimes private individuals can become public figures. You have obviously your politicians and your celebrities are going to be public figures or public officials. Then you have your limited purpose public figures. Those are people who are maybe running an organization that has prominence or importance, and they're representing that organization in the community. They're going to have limited status as a limited public purpose figure. Then you have your involuntary public figures. These are people that are drawn into controversy, not of their own doing, and as a result of that controversy, they become a public figure. And they again, if they're found to fall within that standard, you have to prove actual malice in order to establish defamation. So that's a huge hurdle for anybody bringing a defamation claim in the U.S. I don't know if there's any real pertinent
I was just going to say, if I was trying to sell the UK law of defamation as opposed to the US version of it, I don't think I'd be getting very far, because it's much more restrictive in the UK, clearly.
Okay. Some examples just quickly, because we're restricted on time. Documentary filmmaker Frederick Gertten made a documentary called Bananas. It was about the Dole Food Company. Some of you may be familiar with it. And he was talking about Dole's relationship with their employees and the allegations that their employees were becoming sterile as a result of the use of pesticides, the allegation of the use of pesticides. And Frederick Gertten apparently got a great deal of grief over this documentary, and actually they made claims against him that he made false statements in his documentary, and they sued him, and ultimately made another documentary called Big Boys Gone Bananas, which was a film about the harassment's the wrong word, about the lawsuit that was brought against him and about Dole's reaction to him. And the claim was that basically he was defaming Dole. He was making false misstatements or falsehoods, providing falsehoods about Dole, and Dole dragged him to court over it. And so he eventually, I guess, was so affected by what had happened that he actually made a documentary about what happened. But that's an example of where things maybe hurt a documentary filmmaker, or maybe made a documentary filmmaker feel. It certainly wouldn't have made me inclined to make more documentaries, but I have to say, I think if you're in a situation where you're making documentary film, it's a perfect example of why you should have insurance, why you should try to get releases, why you or licenses, I should say, because that will protect you in those circumstances from having, put in your hand in your pocket and pay out of pocket to protect yourself. Another example is Searching for Sugarman. That's a good example where I think someone, it's a great film, it's an important story to be told, and there was no claim for defamation because there is no defamation. So again, these are different examples. If you ever get an opportunity to watch any of these films, it can kind of give you an idea of where, things might go wrong. And it's like what Andrew said and what Phillip has said, just because if you make a film, you cannot guarantee that someone is not going to, sue you for defamation if your material, if it makes them mad. And you have to be prepared to be able to defend yourself from that. So, I think of people putting documentaries into festivals without having insurance, and it makes me nervous when I hear people doing that, because once that film is aired, that's it. And so it's important to be thinking about these things early on. I don't know if you wanted to talk about Benefit Street.
I do want to talk about Benefit Street, not the programme itself, but about the case that was tangentially related to it. It's the only case so far that has tested out this new serious harm definition, and it was kind of spin-off, as it were, from Benefit Street. It was the Daily Mirror that published a story about It was about a guy who was a landlord in the very same street that Benefit Street was all about. This person owned several properties and was, effectively a slum landlord of the worst type. So as part of this story, which was an expose of this particular person fleecing these, unfortunate residents, he didn't sue, by the way. It's not about him. There was also mention of other people who were landlords in the same street. And one of them was a housing association called Midland Heart, which owned 2 or 3 houses in the same street. And the article said something like, they made reference to Midland Heart, and then they said, its chief executive, Ruth Cook, I think she was called, earns £345,000 a year and lives in a very large house in Gloucestershire. So you had this sort of article which was having a real go at somebody else entirely, but also sort of dragged into it this other entity, this housing association called Midland Heart, and its chief executive and her fat cat salary and her very nice lavish farmhouse somewhere else in the country. And she sued, and so did the housing association. The Daily Mirror realised that it probably, committed a bit of a faux pas and published a fairly quick retraction and apology. But she still carried on with her action. And by the time it went to trial, basically the whole case was about, well, where is the serious harm? So taking all of these factors, the fact it was really not very much about her, but it was about somebody else, and the fact that the apology in particular had already been published, where was the money? Well, could she show that she had suffered any damage to her reputation at all? And the answer was she couldn't. And on that basis, she lost the case without it going further. So really, going back to this serious harm test, unless you can really show some tangible effect, negative effect on your reputation, in particular, a financial one, then a claimant is now going to be in trouble under defamation law in a way that they would not have been before the change in the law.
I think we're running a little bit behind on time, so I'm going to skip the privacy intrusion material, and if we can come back to that if we have some more time at the end. But I want to move on to quickly the business issues, because I do think that, I know most documentary filmmakers are artists, and they're trying to create a product But it's also important that you have to recognize your business too, and your product. People that you're dealing with may like your art, but they also are business people, and they want to make money off your product. And you need to keep that in mind. And Andrew is a perfect person to be talking about the business issues that come up for documentary filmmakers, since he deals with it on a regular basis. So Andrew, I'm going to hand it over to you.
So the key point, obviously, about making a documentary is that you'd like people to see it. It's fairly fundamental. To be able to do that, you have to be able to get it released through distributors, through cinemas, through whatever medium you want to do. And therefore, the key thing that you need to achieve is to make sure that that actually does happen, because otherwise you can't raise money to make more documentaries, you can't repay your investors, you can't recoup all the investment you've made personally. So while all the defences and all the kind of great things that Phillip has been talking about, and Patricia, are great, from my perspective, if you have to get to that stage, there's something wrong. Okay? If you are making a documentary and making a film, you don't have to rely on these defences, because that means you're already in a position where you're on the back foot, where actually someone's suing you and you're in trouble. The best way is to plan and to actually make sure you do these things properly. So it isn't always possible, and therefore some of the exceptions are really, really useful. But from all the production companies I've worked with and all the films I've been involved in, things have gone wrong where people haven't thought through what they're doing to the right extent. And sometimes it's entirely inadvertent, but just that little bit of pause and thought can make all the difference. And I'll give you some examples of that. So I worked on a film for DEFAMATION, which was about an air crash. You know, big disaster, lots of people died, lots of flames, you know, really horrific accident. And the director went out and filmed at an airport because he wanted some establishing shots of planes taking off and landing and all that sort of stuff. And he spent a day and a half, and he came back with the most beautiful footage. It was gorgeous. He had this wonderful shot of the airport and all the planes lined up with all their tail fins and all the colours and everything. It was beautiful. We couldn't use a single piece of footage that he filmed over those day and a half, because effectively every shot had logos in full frontal view. We had no permission from any of the airlines to use any of that footage. And of course, we were talking about planes crashing, and therefore including other airlines that actually didn't crash on that particular occasion was probably just a recipe for a lawsuit, quite frankly. So it's just because he didn't think. You know, no one actually went, okay, why are we making this? What are we actually shooting? Another example, I had a client who did a film about a particular shop. She's a well-known documentary maker, and the interview was great, but no one thought about what was behind the interviewee. And there was a whole series of pieces of artwork. This was actually album covers in this particular instance. And there were probably 30 or 40 album covers in the background. And she had to go back 6 months after having delivered the film and re-clear every single piece of artwork because suddenly she had distribution and it was going to be sold. So what should have been a really happy occasion, which is great, someone wants to show my film and sell it and I can make some money from it, actually turned into a real headache because she'd done that shot and hadn't cleared a single piece of that artwork. And it was a nice long shot, you know, it wasn't incidental, you couldn't do anything about it, it was really obvious. And so she had to go back and clear every single piece of artwork. So just thinking about how you actually plan your production can avoid all these problems. You know, a couple of hours thought up front can save you weeks in the edit, blurring out logos, changing things, and having to go back and clear things. So the general rule is, if you can, get everything cleared. If you're dealing with individuals, make sure they've signed a release form. If you're dealing with kind of pieces of art or any kind of materials from third parties, if you're going to use clips, you know, get them cleared. Yes, you can fair deal them, but if you want to distribute your film internationally, you can't fair deal it. So it's great to have fair dealing, but it's very limited in scope. So I did a show called Elvis in Colour, which was for ITV, and it was non-stop clips of Elvis Presley, which is great. Unfortunately, the Presley estate refused to license a single piece or give us any kind of authority to use it. So we fair dealt the whole thing, but it could only be shown on ITV. We only could show it a couple of times, and it was never sold internationally because there was nothing in it that was cleared. It was all fair dealt. So it was good because we could show the footage and we could make it happen, but it was bad in that we couldn't sell it, so therefore they made no money on it. You know, they couldn't reinvest all the cost. So you've got to be careful about what you do and how you do it. If you're doing a story... Oh, sorry, yes.
What happens when that show's ripped off and put on the internet?
Well, in which case the people who... Yep. Sorry, so the question was what happens if someone takes that and puts it on the internet? Well, the first answer is they'd get sued by the Presley estate potentially because there isn't necessarily fair dealing. They can't get around that exemption. To the extent there's anything unique in it, as a unique copyright work, then the producer could come after them and say, actually, that's mine. You know, you're not using it with permission, unless, of course, they can fair deal it themselves. Yes. So most documentaries are about telling a story. So usually there's something that you're basing this on. It might be an individual story. It might be something that's been in the news. It might be something that someone's written a book about. So you have to think about where is that story coming from. Again, I've been involved in projects where it's been about a real event and it's been reported in the papers. So the producer said, okay, it's been in every newspaper, it's been on the news, it was of historical record, therefore I can make a film about it. And to a certain extent, that's right, you can. But what they were also doing is they were using books written by individuals as part of their research material. Now, one of the things that we came across, or that I flagged very early on, was that one of the books, there was kind of 4 or 5 books written about this particular subject. One of the books they'd used quite extensively. And they made a couple of mistakes. The first mistake they made was they went to see the author with the book, which had more post-it notes in it than I've ever seen in my life. And then, oh, can we just ask you about page 427 where you say this? But they hadn't gone to ask him for his permission or to clear it or to say, okay, can we use the research that you've done? Now, if there's lots of sources all saying the same thing, then generally you could say, okay, well, you know, it's just kind of out there. It's in the newspapers. There's therefore not much there. The mistake they made was that there was one particular fact, or I say alleged fact, that was in this book that was nowhere else. It was never reported in any newspaper. It was in none of the other accounts. The only place this ever appeared was in this person's book. So at that point, it was really obvious that they'd copied directly from his book. It was a dramatic reconstruction, so they couldn't really fair deal it. They weren't giving any kind of credit. They were just using it as part of their narrative. So it was a drama recon of this particular event, and they said, oh, this event happened. It was a statement of fact. This happened. Unfortunately, it only ever happened in his book. So one of the things that we had to do was to say, okay, is there any corroborating evidence? You know, who else says this actually happened? After a lot of digging around, we realised that the guy had made it up. He'd basically sexed up his document and said, oh, yes, this happened, you know, controversial, which is why they wanted to include it in the film. And the answer was he made it up. So there is a salutary tale there, which is, A, if you're going to use someone's material, make sure you've got an agreement with them because he started legal action against the production company. The second thing is make sure that if you're doing something which is saying it's true, that you actually have done your research and it is genuinely true. In this particular instance, there would have been no defamation or anything of that nature, but still the production company's reputation would have suffered because they were saying something had happened that actually hadn't. It had all been made up. So every step of this process, if you actually do your due diligence and you actually sign contracts with people and you get them involved, it makes life so much easier. So if I'm doing a documentary and it's based on somebody famous or someone who's done something interesting, quite often we will approach someone who's written a book about it and we'll say, will you be a consultant on our show? We can use all your research, we'll give you a credit, we'll pay you nothing, maybe a couple of days' work, but it short-circuits all our research and it means that we have clear permission to use that person's time and material. But actually even better, we get access to the primary source material. So we can actually say, okay, so when you say this, where's that from? Oh, you had some letters that no one else has seen. Oh, great, can we just have a look at those? And just as a tip, I would say, if you're in that situation where you're doing a documentary about somebody and there are lots of published materials, it's a great short circuit, but it also means that you can get access to all that primary material and just make sure what you're saying is true. because you've seen, if someone does bring an action against you later, it's really helpful. The other thing to say is that I've been involved in another project where I guess it's akin to Calendar Girls. You know, there's a real life group of people, and the producer wants to make a film about them. And one of the things that we're discussing right now is, are we going to make a film about them, or are we going to make a film inspired by them? And so we could go down the route of saying, okay, well, there's someone called Phillip, and you know, he's a lawyer, and he does this and he does that. If that's the case, we need to actually have a contract with Phillip. We need to have signed something that says we can make a film about you, we can kind of feature you in the program, we can use events in your life. If we're not going to do a film that's about Phillip, but just inspired by the character of Phillip, who has been reported in the news or those sorts of things, then we can do that. But we then need to be very, very careful, because we need to make sure that we're not actually using Phillip, that actually it's not a real person. We might be inspired by some of the things that Phillip does, but we don't want to go down the route of actually using Phillip, because then potentially there might be an action, because it's a recognisable individual. If you sign a piece of paper with them, it's not a problem. So a lot of the things that I did for Darlow Smithson, for example, was involving real-life events. And even though there was some dramatic licence, we had signed contracts with all the original people who were part of those events. And the contract said, we can make some stuff up. We can change things. We can do a dramatic reconstruction. We can have actors playing you without someone saying, actually, that actor was too fat. I'm much thinner than that. My hair isn't as grey. Because genuinely those things do happen all the time. The other thing to look at is we had a question earlier about trademarks and things. Quite often there are a lot of things that you look at in the edit with a different eye, and it's too late to go back and reshoot them. So if you're doing interviews with people, if you're filming on location anywhere, just think about what's actually in the camera. If someone's got a Nike sweatshirt on with a logo and they're in every shot, that's going to be a problem. It's much better for you to go in advance and go, actually, you know what, we're going to just change that shirt. You might have even seen programs on air where people are wearing sticky tape over things. They've got a cap or a jumper or something, there's a bit of masking tape over the top. It looks awful, but it saves you thousands and thousands of pounds in the edit, blurring every single frame. Because if there's a trademark in there, you need to be careful about why it's in there. Is it just incidental, in which case fine. Is it there deliberately? Are you doing something about McDonald's, for argument's sake, in which case you need the logo in there? You know, just be careful about what you're doing and how it works. You also need to think about third-party materials. So if you're going to use clips, that's great. You need to clear them. You can fair deal them, absolutely you can. But you need to be careful about where you're going to then show that film. So if you have some footage from somebody else that you haven't cleared, you might be able to do it in the UK, you might even be able to do it in the US, but no one internationally is going to take your film unless you've cleared all of your material, which means you need to think about either doing 2 different versions, and I've done that before, where Storyville will take one version, and internationally we've got a completely different version. Or you need to just go, no, actually we're going to do just this version. Or you clear everything. The other thing that's a common myth is it's on the internet. It's therefore free. I don't have to clear it. Unfortunately, you do. If someone has shot their dog roller skating or something interesting like that, then it actually is still a piece of copyright work. However low the quality threshold is, it's still a film that someone has made. And in the same way as you would feel aggrieved if someone used bits of your film without permission, they're entitled to feel the same way. If you're using it for criticism and review and all the fair dealing things, great. But again, it's not going to travel outside the UK or the US. So if you do use material from the internet, track people down, get them to sign a release form. It's the best way of making things happen. The other thing to say, if you want to just flick to the insurance just a bit quickly, is just that the point of doing all of this is that ultimately, if you distribute your film internationally and you make sales, you will be required to take E&O insurance out, so errors and omissions. Now, what errors and omissions does is it protects you against inadvertent copyright infringement. What it doesn't do is protect you if you've just been negligent, if you've just not bothered. So part of the E&O process is that you have adhered to some basic fundamental guidelines, which is that actually you have cleared material. If it does feature an individual, they have signed a release form. Now, the piece of the kind of statement that Patricia was talking about is very useful. Channel 4 have a producer's pack, which is free online if you Google it, which is also very useful, which talks about a lot of these issues. But if you're getting an E&O insurance, which is a prerequisite to any distribution deal or any sale internationally, one of the things you have to do is to make sure that you've actually followed the clearance guidelines, that everything has been cleared properly, and also that someone has actually viewed the film and given it the okay. That's one of the things that Patricia and I have done in the past quite a lot, is people actually even have a film, it's been made, they now need insurance, and for whatever reason it hasn't been viewed already. And it's kind of the opinion that we give that gives the insurers comfort that actually they can insure this without there being an immediate problem. Yes.
Rather interestingly, the last broadcast we worked with insisted on insurance before production.
That would normally be the case. So usually if you get a commission, part of the requirements is that you have E&O insurance. Sometimes it can be limited to a particular territory, so you might have E&O insurance just for the US or just the UK. If it's then going to be sold internationally, then sometimes you need to effectively have it re-cleared or reapproved for that extra insurance to be quoted for.
If you're a fairly new director, stroke producer, but more director than producer, is this the argument to get strong, experienced production or producer on side, if you don't particularly yourself want to get your head around all of those bits and pieces, but they're the ones that need to concern themselves with that?
Yes, absolutely. I mean, if you're in a larger production company, then you will have a business affairs team who will kind of make sure all these deals are papered and negotiated. If you're a small producer, either someone in your production team who is more experienced needs to help you, or you need to seek outside assistance from someone like ourselves. There are some really useful forms and paperwork. For example, if you're a PACT member, they have some template agreements. They are what I would call the basic level of protection. They're really helpful and really useful. They're intended as guidelines and basic templates. They don't cover every eventuality.
Yeah, I was just going to ask about the good source for model consent forms and that sort of thing.
Yeah, so I mean, I would say that the PACT ones are really good. I would say just be careful, as with anything in life, searching online for something. It isn't always the right thing that you find. Someone said to me a while ago, "Oh, I've got this form I found online." My heart sank, I have to be honest. And I looked at it, and it was specifically for the US. It was a US form that was used by a US producer, and someone had posted it online, and they wanted to use it to deliver to BBC, and it had missed out a whole series of things that are UK or European law only. So I would say always be careful. Don't just use something because it's online and it's free, and don't use something that's just, oh, I had this on a production a while ago, it must be fine. You have to be careful. So I think we're just about out of time.
Thank you.
One quick thing I just wanted to quickly say, for anybody who's making a film who finds themselves in trouble and they can't afford counsel, if you're in the U.S., it's an organization at Stanford University that helps documentary filmmakers. I don't know if there's an equivalent in the U.K., but certainly if there is, the Stanford University project will know. So look them up. It's important to use them as a tool. So just to let you know.
Okay, I think that was us. Thank you very much. If there's anything else you want to ask us, please come and say hello.
Yes.
Failing that, enjoy the rest of the festival. Thank you.
Thank you.